Well, hello and welcome again. Disability Law Show. John Scholes here. Beside me, James Fireman, Samfiru, Tumarkin, LLP, the most positively reviewed disability law firm in the land. James representing, of course, back for another week to educate you all about disability law. There's so much you probably don't know about it, but that's okay. The safety net, the first safety net is this 30-minute TV show. If you want to go to disabilityrights.ca, that will land you on the firm website. From there, there's a media tab, and you'll find radio shows that James and I host across the country. You can tune into those anytime. In fact, we'll probably get to some phone calls on this show from the radio show as well. How to get LTD payments if you suffer from a mental health illness. I know, seems like a terrible mountain to climb, but it is possible. You just need the help of someone like James and his team. You want to reach out anytime? Easy. 1-855-821-5900. Help at disabilityrights.ca. There's some more contact throughout the show I'll give you, but that's enough for now. James, we always start with the situation you have been working on. The week that was, pal, what do you got?
Well, I want to talk about a common misconception that a lot of people have when they become involved in the disability process. And there's a reason that they have this misconception. So what I'm talking about is the belief that in order to get disability benefits, you require objective medical evidence. The reason a lot of people believe this is because this is what they are told by their insurance company. So it sounds like something that they're going to require in order to get paid. But if you take a look at the policy, or if you take a look at the law, there's nothing in there that says you need to have objective medical evidence. What the focus is on, what you require, is a medical condition that causes a functional impairment that prevents you from being able to work. So whether or not you have a diagnosis or an X-ray or any other piece of medical evidence that proves that you have a particular condition isn't a necessary step in order to get disability benefits, nor will it ensure that you get the benefits if you have that. Even having a diagnosis doesn't mean that you have a sufficient level of functional impairment. The analysis is always going to be on what is your disability and in what particular ways is this preventing you from being able to do your occupation. And the reason this is really important is because there are a lot of people out there that suffer from conditions that you cannot prove with objective medical evidence for any number of different reasons. In some cases, we're talking about mental health issues. In other cases, we're talking about physical issues where medical science has yet to advance to the point where it's able to determine with any reliability in a way that can be confirmed in black and white that this is what this person is suffering from. And we see it all the time in the context of chronic pain, which, by the way, is something that our Supreme Court has said time and time again is compensable. If you suffer from chronic pain, you're entitled to benefits or damages depending on the root of your legal claim. And so this brings us back to a case that I'm dealing with at the moment. And it involves a gentleman who had a procedure a few years ago. And following that procedure, he started to experience extreme pain all over his body. They went back to figure out if there was something that happened during the procedure, and there's no evidence that it did. He just seemed to have had a reaction to this procedure that nobody can explain. He has gone to his family doctor, of course. He's gone to emergency. He has been sent to any number of different specialists. He's gone to see a gastroenterologist. He's gone to see a general surgeon, a doctor of internal medicine, a chronic pain specialist. You name it, he's seen it. And every single time they say, we can't figure out what is causing this person's pain. And so this is the type of person who I'm talking about, someone who has a real disability. He's got a limitation where he can't sit for more than 3 or 4 minutes. He can't walk for more than 4 or 5 minutes. There's no reasonable way somebody who's in that kind of pain is going to be able to work. Now, believe it or not, his insurance company actually did approve him for benefits, at least initially, and they paid him for 2 years. But then at the 2-year mark, they cut him off. The 2-year mark, as we know, is the change of definition, when the entitlement to benefits now requires that you prove that you are disabled from doing any occupation. But here's the thing. The job that he had before he became disabled was a sedentary position. He worked at a desk. And so it didn't really make sense that now at the change of definition, all of a sudden, he's going to be able to do something else that's also sedentary. But of course, that was what the rationale was, that he could do a sedentary job. It just simply did not make any sense. Then he appealed, which, by the way, and I know we're going to talk about this at some point later in the show, you shouldn't do. But nonetheless, he did appeal. And this time they changed the rationale, not their decision, unfortunately, but they changed the rationale. Now they said that the reason why they wouldn't pay him benefits beyond 2 years is because there was no objective medical evidence to prove that he had this disability, which is a strange position for them to take, John, because the last 2 years, they had agreed that he was totally disabled, despite the fact that he did not have any objective medical evidence. So we're coming up on mediation very shortly, and I'm going to be very curious to hear what the insurer has to say, because they have really backed themselves into a corner on this. They've tried to justify it in two ways that make absolutely no sense whatsoever. And incidentally, here's the kicker for you. They had his file reviewed by two doctors, both of whom said that he is genuinely disabled and is not able to do even a sedentary job. So there you go.
Talk about digging your heels in, man. Would it be? Is it oversimplified to say that based on receiving your benefits, going back to your original point, without a diagnosis, it's based on the symptom, not the diagnosis? Because to your point, we could be decades away from realizing what's causing this man pain. Doesn't mean he can work.
That's exactly right. The focus is on the symptoms, on how those symptoms functionally impair you. It's not enough to say that you have a particular diagnosis. In this case, he has subsequently been diagnosed with chronic pain, but that's not an objective diagnosis. It's not something where you can show in black and white that this is what you have. It's really more of a description of the symptoms that he's suffering from more than anything else. But saying that he has chronic pain doesn't show the extent of his functional limitation. That's seen when all the medical records refer to his limitations for being able to sit for no more than 2 or 3 minutes, and he can't walk for more than 4 or 5 minutes. When you can consistently show that kind of functional limitation, that is what you need in order to be able to prove that you are sufficiently disabled to be entitled to benefits.
You know, it's interesting too, because past the 2-year mark, this guy is still suffering, still cannot work, still can't function. He still needs to be off. But regardless of whatever backup, whatever medical information that insurance company had, as soon as they hit that 2-year mark, which I know you'll explain a little bit more to the viewers what that means and why things change there, it's like it goes off no matter what. Oh, 2-year mark, we're going to cut you off, or by the way, you're going to get cut off, even though nothing has changed with me. I still can't work, right? Explain that a little further with that 2-year mark.
Sure. So after 2 years of receiving benefits, the test changes. For the first 2 years, the test is whether your disability prevents you from doing your own occupation. After 2 years, it's whether it prevents you from doing any occupation. So in many circumstances, after 2 years, it becomes a tougher test to pass. In this particular case, there's no reason why it should be, because he was doing a sedentary job before. And he's not suffering from any cognitive or psychological issues that are specific to his job where he wouldn't be able to do it anymore. So any other job, any other occupation that they say he's going to be able to do isn't going to be more physically demanding than the job that he had before, or less physically demanding than the job that he had before. So it really is irrelevant for someone with his type of issues hitting the 2-year mark. It shouldn't matter at all. That they said that it did, that they reassessed his claim and cut him off, is bogus. There's absolutely no justification in this case for them having cut off his benefits, and they know.
Again, reaching out anytime to James, really simple, 1-855-821-5900. He's got a whole team behind him ready to help you. help@disabilityrights.ca. And there's a website we put together. It's more for we do the other show, the Employment Law Show, of course, James, and pocketemploymentlawyer.ca is a big website. People use it all the time. And why? It's about employment. Yes, it is, but there's a very robust section on disability law. Lots to be learned there as well. If you're suffering from disability, dealing with an insurer, the appeal process, all that stuff. Again, pocketemploymentlawyer.ca. Want to tell you to go over there and check out the section on disability law. But I want to get to an email, as we promised to, that, and maybe some phone calls later. Again, help@disabilityrights.ca. James, this first one is from Sharon. Sharon writes in, says, my claim for long-term disability benefits was denied. Even after I submitted tons of information from my doctor, a friend told me that before I can go to a lawyer for help, I must first exhaust all possible appeals with the insurance company. Is this true? I wonder what all means.
That's a hard
30?
no, Sharon. Except for a narrow subset of people who are unionized. Most unionized people, this will not apply to at all. There are a few unionized people that do have to go through a particular process, but they are very much the exception. For the vast majority of people and anybody who's not in a union context, you don't have to do anything before you talk to a lawyer. In fact, even if you are in a union context, and this applies to you, you still don't have to do anything before you contact the lawyer. Certainly not this one. And the reason why is because we offer free consultations no matter where you are in the process. If you have a question about your disability insurance claim, whether you're applying, whether you're during adjudication, whether you've been denied or you're on claim, you can give us a call and you can find out what's up. We're happy to help. And there's no charge, of course, for that consultation. The reality, though, is that the idea that you have to exhaust all appeals is entirely untrue, and it really doesn't make sense in practice. First of all, appeals are entirely optional, and there's something that insurance companies have invented in order to prevent you from talking to a lawyer. And it doesn't prevent you, that's really the wrong word, to discourage you from talking to a lawyer. Right. They want to provide you with the opportunity to do something else in order to challenge their decision. But the something else that you're doing is playing by their rules. You're essentially saying, okay, insurance company, even though you're not listening to the treating doctors that are telling you that I can't work, I'm going to give you another chance. Why would you do that? Why would you give them the opportunity to continue playing by their own rules? If you take it out of their hands, then they all of a sudden have to be reasonable. And if you think that you're going to go through the appeals process until it's exhausted and then talk to a lawyer, I've got news for you. Most insurance companies don't have a limit on how many appeals they're going to do. I've had clients that have appealed 3, 4, 5, 6, even 7 times. The idea here is the insurance company wants to keep you in that appeal loop. They want to keep you there for up to 2 years from the date that they deny your claim or cut off your benefits. If they're able to do that, if they're able to keep you in that appeal loop for 2 years, then you are no longer entitled to bring a legal claim. Yeah. And once they've exhausted that period of time, then you're out of luck. There's nothing you can do. They're not going to take your appeals anymore. And if you call a lawyer, they're going to tell you, sorry, but you've missed the limitation period. There's really nothing that I can do.
Yeah, and that appeals process, again, we always say this, it doesn't go to, some medical board or some provincial overseer. It's an internal thing. It's the insurance company you're just giving it right back to.
Yeah, insurance companies like to sell the idea that the appeal process is this standalone thing where it's very official and it's going to be sent to some independent third party who's going to look at it with fresh eyes, objectively, without an interest. That's not true. What happens in almost all cases when you appeal is it goes back to either the same claims handler who made the decision in the first place, or sometimes someone directly above them. But generally, it's the same people that are making the decision, and their incentives are the same. Mm-hmm. The insurance company has an incentive to cut off your benefits or to deny your claim. They're a corporation. They have shareholders, and their interest is in making profit for their shareholders. That's what they're there to do. They're not there to be your safety net. They're not there to hold your hand. They're not there to do things for you. They're there to do things for their shareholders. That's all there is to it. And if you believe otherwise, you're asking to be fooled. That's really what it comes down to. So don't buy into the appeal hype, because if you do, you're going to run around in circles, and eventually you're not going to have any options.
Coming up, how to get LTD if you suffer from a mental illness. Important stuff, that's on the way. But first, we'll take a short break. To reach out to James anytime, 1-855-821-5900. And that email address is help@disabilityrights.ca. It's a disability law show. Stick around, lots more coming up. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help. Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Disability Law Show. John Scholes here. James Fireman beside me. Samfiru Tumarkin, LLP, the most positively reviewed disability law firm in the land, in the entire country. Reach out and make that phone call. Get some answers. Have a chat with James or a member of his team. No problem. 1-855-821-5900. Email is help@disabilityrights.ca as well. James, getting into the topic of the show for today, and that is how to get long-term disability payments if you are suffering from a mental illness, mental health issues. Number one, seek medical attention as soon as you begin to feel unwell or exhibit symptoms. Talk about it.
I do want to just give a couple general comments about the topic. First of all, if you have a mental health issue, you should understand that you are in good company when it comes to disability benefits. I would say, going back 2 or 3 years, at least 50 to 60% of my cases involved clients that had either primary or secondary mental health issue. That number has certainly gone up over the last few years, particularly since the start of the pandemic.
Yeah.
So if you have a mental health issue and you're concerned that you might not be entitled to disability benefits because it's not a physical disability, that is certainly untrue. You absolutely are entitled. And if you have any questions or concerns, you know who to call. So let's get back to this top 5 list here. And so number one, seek medical attention as soon as you begin to feel unwell. So anytime we're talking about any medical issues, I always feel it's necessary that I qualify my comments by making very clear I'm certainly not a doctor and you want to rely on your doctors for any medical advice. But this is common sense. If you have symptoms, if you are struggling with your mental health, you should seek medical advice as soon as possible. And what I see time and time again when I look through medical files is commentary that confirms that seeking medical help, getting treatment as early on as you can, is the most positive factor in terms of whether or not that treatment is going to be effective. That's the highest correlations. If you get treatment early on, you have the best shot of being healthy down the road. And ultimately, that's what you want. Whatever happens with your disability benefits, your health is paramount. So get treatment early.
Second point is this one, James. Keep track of all medical appointments, symptoms, prescriptions, all that stuff, medications you're taking as well. Keep a record of all that stuff, right?
Sure. And again, this is common sense. This makes a lot of sense and it's helpful in terms of your medical care for sure. When you're dealing with your doctors, being able to make sure that you have a comprehensive list of everything that's happening can be very useful for them, especially if one of your issues involves cognitive function and your memory or concentration. You might have difficulty coming up with it on the spot. So having that record can be very helpful. It's also helpful in the context of a potential future legal claim, so that if and when you're involved in that process, you're going to be able to rely on your own records in order to answer any questions your insurance company has about the history of your condition, about what treatment that you've had, about how you felt over however long it's been since your disability set in.
What we're talking about today, by the way, again, is how to get LTD benefits if you suffer from mental health issues. Number 3 is this: follow all the prescribed treatments, medications, etc. from your doctor. Follow that medical team's advice.
Okay, and again, I think all of this, there's a very strong element of common sense involved here,
Sure.
Of course. Your doctors are the ones that you rely on for medical advice, and if they're telling you that you need to take this medication or get that treatment, then follow that advice. Obviously, that's what you should be doing. But in terms of the disability claim, it's even more important because your disability policy has a requirement in there that if you do not follow recommended treatment, your insurer has the ability to deny or at least stop paying your benefits for the period where you're not getting that treatment. So you want to be able to show that you have done everything that you can to follow all recommended treatment. Now, just a caveat here, that doesn't mean that if you're prescribed a medication and you have a bad reaction to it, that you're required to keep taking it in perpetuity. Not at all. if you're taking medication and you have a bad reaction, immediately go back to the doctor that prescribed it and tell them what's happening. And I suspect in most cases, they're going to discontinue that medication and there will be a record of that in their file. And so then if you stop taking it, you are again following your doctor's recommendation. So it doesn't mean that just because it's been recommended at the outset that you have to do it to the point where you're in pain or you're having some side effects that are causing you discomfort unnecessarily, not at all. But otherwise, follow the treatment recommendations, of course.
And number 4, again, you want to chalk it down to common sense, but sometimes people put this one off as well. That is apply for benefits through your employer or third-party insurance plan. How about that?
Yeah, and listen, if you're not sure, not everybody is up to date on what benefits they have, then find out. Talk to your HR department, ask what your benefit plan is, whether you have coverage or not for disability benefits. And remember, that can include both long-term and short-term disability benefits. So find out what coverage you have, and depending on your coverage, make sure that you complete the application in a timely way. Typically, when you apply for disability benefits, there's usually 3 forms that need to be completed. One of them is a form that your primary doctor is going to fill out. Usually, it's going to be your family physician. On occasion, it might be a psychiatrist or a psychologist, and certainly in the context of mental health, that can be appropriate. There will also be a form for your employer to fill out, and then there's a form that you fill out with your general information. These aren't especially onerous. They're not difficult to fill out, and so please make sure that you do that in time.
Last one is this, and kind of an obvious one too. When you've gone through all this and there's a problem, you want to reach out to James, talk to a disability lawyer if you're having any issues with your claim, right?
Yeah, absolutely. We're happy to talk to anyone wherever they are in the process. I mentioned this earlier, but wherever you are, if you're starting out and you have been off work for a few weeks and you find out that you have disability insurance and you want to just get a little bit of advice about the process, about who should be filling out the forms or what information to put in there, give us a call. If you've applied and you're concerned about the initial response from your insurance company, give us a call. If your insurer has rejected your claim, give us a call. If they've approved your claim and you have issues with how your claims handler is dealing with you or what they're asking you to do while they're paying you benefits, we're happy to talk to you then as well too. It's a free consultation.
There's another way to ask questions anytime to James and his team and a member of the firm as well. That is mydisabilityquestions.com. It's free and anonymous. I'll give you more details on how to use that, and we'll refer to it, go to it, after a short break. The number, reaching out to James anytime, 1-855-821-5900. Email address we always use, help@disabilityrights.ca. It's the Disability Law Show, and there's more coming up.
People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back. Just before the break, I mentioned a website called mydisabilityquestions.com. It's exactly that. It's a free and anonymous website where you can ask your disability questions. And the algorithm's built in such a way that it's searchable. So something you asked may have been asked by someone else previously and answered. It'll save you some time, right? If not, leave the question there. Either James or a member of his team will answer it and give you a reply. Again, mydisabilityquestions.com. For today, James, it's going to be Wayne. Wayne writes in, says, and this question's amazing. We pulled this out of a pile because this has happened so much now in the last 2 years. He says, I've been receiving LTD benefits for over 3 years, but my company may be shutting its doors because of difficulties posed by the COVID-19 pandemic. How does this impact my disability benefits? Will they be cut off? Not the first time you've heard this.
No. And Wayne, great question. And I've got good news for you. The answer is no, your benefits aren't going to be cut off just because your employer goes out of business, if that does happen, of course. And the reason is pretty simple. When you apply for disability benefits, as long as you have coverage at the point you become disabled, that coverage and that entitlement to benefits continues for as long as you can show you meet the definition of disabled under the policy, right up to age 65, regardless of your employment status. So if your employer shuts down, you're still entitled to continue on with that existing claim, as long as you continuously meet the definition of disabled. If you're terminated by your employer, same thing. Doesn't change your entitlement to get ongoing disability benefits if you meet the definition. So you don't need to worry about it from that perspective. One caveat though, if your employer does go out of business and if you're paid any kind of severance or termination pay, as a result of that, that can impact your payments. Not your entitlement to benefits, but how much you're getting during the time period that you're getting that severance or termination pay for. So if they pay you, let's say 3 months termination pay, whatever it is, during those 3 months, in all likelihood, whatever your benefits would have been from your insurer are going to be reduced probably to nothing during that 3-month time period. So you're not likely going to get much of a benefit from the severance pay at the end of the day. But once that severance runs out, once that time period that you're getting those payments for runs out, then as long as you continue to be disabled, your benefits would kick back in and you start receiving the monthly benefit check from your insurance.
Wayne, nicely done. Appreciate that note on mydisabilityquestions.com. You can always call now, 1-855-821-5900. We'll quickly get to Daria's email, James. It says, my LTD payments were abruptly cut off after 2 years. The insurance company believes I can do a sedentary job instead of my previous position in a group home. I don't know how they arrived at this conclusion, as my doctor believes my back injury is still severe and I'm not able to work.
Well, Daria, here's the thing. The analysis, using the word severe is great, but that doesn't really tell me a lot about the extent of your functional impairment. And I don't doubt that it's significant and warrants that label severe, but really we need more information in order to be able to assess this. The focus, as I say time and time again, is on what your functional limitations are. What are your symptoms? And so if you have a severe back injury, I want to know, what is your sitting tolerance? How long can you sit down at a desk for before it becomes too painful for you to be able to reasonably function? How long can you stand for? And how many times might you be able to alternate between sitting and standing throughout the day? I'd like to know what your doctor says about that. And I find very often when people do have severe back injuries, that type of information will be somewhere in the file. And that's really the pertinent information when you're looking at an insurer who's suggesting that you should be doing sedentary work. If you have a significant limitation for sitting or for standing, are you reasonably going to be able to alternate on and off for an entire day, or a week, or indefinitely? Almost certainly not. Most people in that situation can maybe alternate a couple times before they really have to go and lie down until they significantly improve from treatment. So that's the type of information that I would really want to see. And as long as your doctor is willing to support that, then you should be entitled to your benefits. And it's something that we ought to be able to help you.
Daria, appreciate that email. You want to reach out with a phone call now that we're just about ready to wrap up for the day. Here is how you do that, 1-855-821-5900. It is help@disabilityrights.ca. That was the email address Daria used. And if you want to go to mydisabilityquestions.com, again, free anonymous website for you to ask your questions as well, mydisabilityquestions.com. Thank you, James, and thank you for watching. We'll catch you next time, The Disability Law Show.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca.